May it please the Court, Counsel, my name is Tania Lex, and it is my honor and privilege today to represent the state of Minnesota before you. This case has drifted a bit from where it began at the district court level, so I think it's important to remember the issues that were actually at stake at the Court of Appeals level. This is a DWI case, obviously. Ms. Netland was arrested for DWI, brought to the police department, read the implied consent advisory. She verbally agreed to take a test, but there was some testimony from the police officer who administered that test, as well as a recording that someone indicated that she was not cooperating, perhaps trying to alter the results of the test by her conduct. There's also testimony from Ms. Netland herself, and as well as from the police officer, that she was asking for another test when she was deemed to have refused the test.
Counsel, I want to ask you a question factually about the Intoxilyzer machine. Help me understand the record. As I understand it, the machine manually shut itself off after 4 minutes. The officer didn't shut the machine off. Am I right about that, or am I wrong about that?
Your Honor, the machine, I believe, is designed to shut itself off after 4 minutes. But I'm not sure the record is entirely clear whether that was the case or not here. There was quite a bit of conflicting testimony regarding whether Ms. Netland was actually given 4 minutes or not.
There was a conflict in the evidence about that.
Correct, Your Honor.
Counsel, is that, I think it's 3.5, 4 minutes. The record is not clear whether there is the full 4 minutes. There's something in the record to indicate that it may have shut off after 3.5 minutes. Would that be a fair statement?
There is evidence in the record to indicate that Ms. Netland was not given the full 4 minutes to test. Your Honor, after Ms. Netland was convicted of test refusal, she brought a motion for a new trial alleging due process.
Counsel, let me ask a question just for background. Do I understand the record correctly to indicate that one indicated that she would submit to a blood test?
Yes, Your Honor.
Before the
testing process? I believe so, Your Honor. Ms. Netland's...
And the statute makes refusal to... statute deals with the refusal to take a blood, breath, or urine test, correct?
Correct.
Having asked to take a blood test, how do we get to a refusal to test?
Well, Your Honor, under the current state of the law, the officer is allowed to choose the test. In this case, the officer chose a breath test and testified that he normally does so because the equipment's right there at the station, and it's easier for him.
Counsel, as I look at, and I've looked at these cases over any number of years, quite frankly, if I were in her situation, I'd probably ask for a blood test because that is tangible evidence that is probably one of the most reliable ways to determine blood alcohol contact. So in the context of the law where you're facing criminal prosecution, what gets us to the point that when the statute says you can elect different tests, the officer gets to choose contrary to your desire, and then we're bound by that? I'm not saying that's not so. I just want to know, because you said we have the factual situation. The statute allows blood, urine, Intoxilyzer breath test. They allow you to choose. She said, I want the blood test. And it appears to be indisputable, the officer said, breath test, because I decided that was most convenient. And so how do we get to the point that this sequence we defer to the state, where a liberty interest is at stake?
Your Honor, am I understanding that you're saying the law allows the defendant to choose blood, breath, or urine? Because that would not be a correct statement of the law. The law allows the officer to choose blood, breath, or urine. If the officer chooses a blood or urine test, he must offer the defendant a choice of the opposite one. If blood is offered, the defendant can choose urine before it's deemed to be a refusal. But if the officer chooses a breath test, the defendant does not have a choice to ask for another type of test under the current state of the law.
And that's 169A51 subdivision 3, right?
Correct.
Counsel, it's my understanding of the state's statutory interpretation argument that your argument is that there is a definition of refusal in the statute, and it's the definition of refusal in Section 169A.51 subdivision 5C. Is that correct? That is included in the definition of refusal? Yes. Well, what's the state's position about how refusal is defined for purposes of the criminal test refusal statute?
Well, Your Honor, the Court of Appeals decided that section that you refer to, defining refusal as failure to provide two adequate breath samples, is not incorporated into the refusal statute. The state takes the position that it is. However, above and beyond that, the state takes the position that the issue never even actually needed to be decided and was not squarely presented to the court. The only reason that it would need to be decided whether that was incorporated into the refusal statute is if the jury was explicitly instructed that they could find that Ms. Netland refused based solely on her failure to provide two adequate samples. However, the jury was not instructed that way. They were instructed only on refusal itself, that refusal is a crime. Refusal was never outright explicitly defined.
And it's your position that, is it your position then that we don't have to reach the statutory interpretation question? In other words, we don't have to decide in this case whether Section 169A.51 is incorporated into the criminal refusal statute. We don't have to decide that question in order to answer the due process issue presented?
No, Your Honor, I don't believe you do. For the first reason being that the jury was not instructed that way. The second reason being the way the court defined refusal as indication of an unwillingness to submit to the test. In this case, we do have evidence that Ms. Netland indicated an unwillingness by conduct.
So the jury was instructed that refusal means, what was the jury instructed on?
There was no instruction on what refusal means. They were simply instructed that refusal to take a test is a crime.
A question for you about, it may seem somewhat collateral, but I just want to explore the idea that a defendant has a due process right to preserve evidence that may be exculpatory. And I know that I apologize, I don't have the cites right now, but for example, if a defendant is picked up for a crime, we have some case law that says if a defendant is going to claim, and we've had some cases, that I was too intoxicated to form intent. And maybe you can help me with the cases. I was too intoxicated to form intent, that the defendant in that circumstance has an absolute right to have their blood drawn, to preserve for their defense in the underlying criminal case their assertion that they could not form the intent. And I want to ask you, and that's a due process, that's grounded in due process. Why does that principle not possibly apply here? The defendant here is saying, look, I want to preserve my blood. I want to preserve some evidence. This test isn't working. I want a different, and most people would agree, a more reliable test to preserve for my defense in the underlying action that I was not intoxicated. Why is that principle not one that we'd consider?
Well, Your Honor, I guess I'm not familiar with the case that you're referring to, but in this case, Ms. Netland, I don't believe, has claimed at any point that she was too intoxicated to form an intent.
Well, and counsel, more to the point, though, wasn't she given exactly the opportunity that Justice Meyer's question highlights? I mean, the officer did give her the opportunity to gather an independent test so that her rights to present a complete defense, I mean, isn't that the State's argument, that her rights to present a complete defense were vindicated because she was given the opportunity to have an independent test, and the results of that test, in fact, showed that she was under the legal limit?
Yes, Your Honor. That was going to be my next point, actually. The DWI statute allows for an independent test once the defendant has submitted to the State's requested test, and she had the opportunity, and she did take the opportunity, to secure an independent test for herself.
And what were the results of that independent test?
The result, I believe, was .0336.
6? Is that a violation of the driving under the influence statute when you have a reading like that?
Your Honor, it's not a violation of the driving with the blood alcohol concentration over .08. She could still have been driving under the influence. Obviously, in this case, the jury found that she was not guilty of driving under the influence.
So there's something odd about someone asking for a test that's permitted, being required to take a different test, and be charged with test refusal. When they end up taking a separate test, the result is that they're under .08. Now they're criminally liable for the refusal. Somehow that is a proposition.
Your Honor, there was evidence presented at trial that the results of the second test that Ms. Netland took had been tampered with or were otherwise unreliable. But to address your point that you seem to be uncomfortable with, the fact that somebody could have requested a test that's permitted and then be convicted of refusal for being, when they're asked to take a different test, Your Honor, I think that that's a decision that the legislature is allowed to make. It may seem a little bit odd, but I don't think that it violates fundamental fairness. When we're talking about due process, the standard is violations of fundamental fairness and things that shock the conscience, and I don't think it rises to that level, even if it does seem a little bit odd. Your Honor, in Ms. Netland's original brief, she alleged 4 violations of due process. The fact that it violates due process to criminalize failure to provide an adequate breath sample in addition to outright refusal. We've talked about the fact that the court did not need to reach that issue for the reasons that I mentioned. She talked about the fact that it violates due process to convict a defendant for test refusal when the defendant provided 2 otherwise adequate samples that were rejected by the machine for unknown reasons. She claimed that it violates due process to disallow her a second test when she clearly wanted to take a test, and that it violates due process to give Ms. Netland a full 4 minutes, or to fail to give Ms. Netland a full 4 minutes to take the test. The Court of Appeals' most fundamental error in this case was a misapplication of the standard of review. It almost seemed to be a mix of a due process analysis with sufficiency of the evidence analysis. However, if the Court's intention in this case was to evaluate the case for sufficiency of the evidence, the Court failed to apply the proper standard, and that it failed to evaluate the evidence in the light most favorable to the jury. And the Court seemed to completely ignore, just dismiss, evidence that clearly supports the jury's guilty verdict. In this case, we had the testimony of Officer Hagen that Ms. Netland's refusal was supported by her conduct, though she said that she would take the test. She persisted in a number of behaviors that would have affected the test results, blowing very lightly, pretending to blow, sucking in air, stopping and starting, various things that based on the context, the officer perceived as her attempts to affect the test results. And if the court is going to be evaluating the sufficiency of the evidence, the court must assume that the jury believed any testimony that was contrary to the verdict. And if the court had applied that standard, it would have found that the evidence was sufficient to support Ms. Netland's conviction. If the court intended to make a due process analysis, the court's due process analysis rested primarily on the fact that Ms. Netland had never indicated that she was unwilling to take a test, and that refusal requires an indication of unwillingness. However, if the court wanted to rest their holding on due process, they should have remanded the case to the district court to make factual findings rather than making up their own factual findings. Here, the district court made no findings on Ms. Netland's due process motion, and though the legal standard for a due process is de novo, factual findings must be reviewed for clear error. Since no factual findings were made and the facts are in dispute, the Court of Appeals is not authorized to put its own spin on the facts. In certain situations, factual findings are not required. The Court of Appeals does not need to remand for factual findings, but that's only when there's no dispute and the evidence is essentially undisputed. And here, there are factual issues to be decided.
So is it your position, is it the State's position that we can't rule on the due process question? We can't decide whether or not Ms. Netland's due process rights were violated? We have to remand the matter back to the district court for more fact-finding? Is that your position?
That would seem to be the proper course of action, unless this Court's interpretation of the district court's ruling is that it intended to evaluate for the sufficiency of the evidence.
Well, who has the burden of proving? Is it Ms. Netland's burden to prove that her due process rights were violated, or is it the State's burden to prove that they were not violated?
Your Honor, I guess I can't remember the answer to your question, but either way, it would seem to me that that would happen at the district court, and that the district court would make the determination of the evidence, and the appellate court would review for clear error.
Well, as I'm understanding the argument at the district court, the only argument that was pressed in the motion for a new trial at the district court was my due process rights were violated because I was not given a full 4 minutes to take the test. That was the only, as I'm remembering it, correct me if I'm wrong, but as I'm remembering it, that was the only basis argued for due process to the district court.
That's correct, Your Honor.
And if Ms. Netland has the burden of proving that her due process rights were violated, and if, as you've suggested, the evidence is in dispute about whether she was given 4 minutes or not, one witness said she was, another witness said she wasn't, wouldn't that mean that she didn't carry her burden of proving that her due process rights were violated?
Yes, Your Honor.
So why would we need a remand?
Your Honor, I guess the district court didn't base its holding necessarily on the 4-minute determination. In fact, the Court of Appeals in Netland, I believe, noted that there was some dispute about whether she was given 4 minutes. The Court of Appeals based its determination on the fact that she should have been given another test because she was willing to take a test and trying to take a test. There's never any claims or determination made on that in the district court.
Counsel, looking at, I believe your argument is that if we look at the 169A 51(5)(d), I believe, which deals with the revocation of license. Clearly, that's the revocation statute. But it sets out what the standard is for revocation of license. Is that correct?
Yes, Your Honor.
And you would agree that 169A 551 is a civil remedy or civil action as opposed to a criminal, correct?
Yes, Your Honor.
And if we were to take the respondent's argument that the for purposes of Section 169A.52 revocation only applies to the civil statute. What is the standard that would be applied, or how should we determine whether there was a refusal in this case? I mean, is there an alternative way to ascertain what constitutes a refusal as opposed to relying on 169A.51?
Yes, Your Honor, and I think the Court of Appeals correctly identified that as the plain meaning of the word refusal indicates an unwillingness to, and as the Court of Appeals pointed out, a person could do that by words or by conduct.
And then, if that is, so it's, refusal can be demonstrated by words and conduct. And so now that becomes a factual determination.
Yes, Your Honor.
What is it here that indicated there was a refusal? What was done by words or conduct that indicated that there was a refusal such that it could be sustained as a criminal violation?
Your Honor, the testimony of Officer Hagen establishes the refusal, where he testified that Ms. Netland, though she verbally agreed to take the test, was failing to blow, was pretending to blow, was starting and stopping. I believe he alleged a few other behaviors that she was engaging in, sucking in air through her nose, and essentially trying to alter the test results of the breath test.
Now, I assume that you've listened to this tape and the sequence between here, and is that there's comments on that, and there's some commentary that the officer's conduct was maybe not what you would model the conduct in here as with respect to getting this information. Would you agree with that?
I would not agree with that, Your Honor.
Okay, so that the officer did everything the officer should do here and did everything in a way that was consistent with us reaching a conclusion that there was a refusal for purposes of a criminal statute.
Yes, Your Honor. I believe that everything was done properly, such that there were no violations of due process.
So how much time must an officer allow someone to complete the test? I mean, it appears that if we take this evidence benefit of Ms. Netland, she was allowed 3.5 minutes. Is a minute going to satisfy? Is 2 minutes going to satisfy?
I don't think you can.
I mean, how do you, or is the time frame irrelevant here? Are there other factors completely devoid of the time frame?
Your Honor, I think the answer to that question is a reasonable amount of time. Though there used to be a rule requiring 4 minutes, there was case law at that time that said the 4 minutes encompassed not only time for the defendant to blow into the Intoxilyzer, but also time for instructions, pausing between blows, and different things like that. So the 4 minutes would not have been completely time. The entire time the defendant would not necessarily have been using to blow into the Intoxilyzer. The proper standard, now that we don't have a 4-minute rule requirement, would be a reasonable amount of time.
Counsel, do you concede that if the officer had offered this individual a blood test, she would, I mean, does this record indicate she would have consented?
It sounds like it, Your Honor.
And she would not then have committed a crime?
Correct, Your Honor.
You have to admit, factually, this case is unique. I mean, the statute contemplates that people will not agree to blood tests. And then we get into this question of they're engaging in a test where their cooperation is required. And then we get into the whole question of when does your non-cooperation become a refusal?
It's true, Your Honor.
Okay. Counsel, you've reached the end of your time. You have 10 minutes for rebuttal. Thank you.
Thank you, Your Honor.
Mr. Ramsay.
Actually, Mr. Ramsay, you moved the microphone away from yourself, but actually this is being recorded, so it helps if you have it in front of you because it gets a clearer audio record. Thank you.
May it please the court, counsel, my name is Charles Ramsay, and I represent the respondent, Ms. Netland.
Counsel, let me ask you this. Does this case turn on the impact of a transitive verb? Because that's how I read the Court of Appeals opinion. The Court of Appeals says that the officer doesn't get to choose the test because there's a transitive verb in the statute, as opposed to whatever is the opposite of a transitive verb. Is it that fine?
Your Honor, are you referring to where the statute says it's a crime to refuse to submit? Is that what Your Honor is asking?
I mean, when I read the statute, I went to 169A20 subdivision 2, and I have to say my first inclination was that it said you follow 51 and 52 to decide whether there was a refusal to test, and that's not what the Court of Appeals said. They basically said there is no right of the officer to choose a particular test, and once your client said, I'll take a different one, she had the right to control that, and that just doesn't seem right to me. I'd like you to explain why it is.
Your Honor, I think the Court of Appeals properly interpreted the statute, but I don't think the issue revolves just around that, Your Honor. I think it's a much broader issue. The issue really is, can the state compel a person under threat of incarceration to submit to a test under the Fourth Amendment?
Well, okay.
That's
a different issue than what I'm talking about.
Yes, Your Honor.
I'd like you to answer my question.
And I guess I'm not trying to sidestep it, Your Honor. I don't properly, or I don't know if I understand exactly what you're asking. That is Your Honor asking if an officer is entitled to decide which test to take?
I think it's clear that under the civil implied consent law, what 169A51 says, let's see, I had it right here. It says the officer basically has the right to decide what test is going to be administered.
Yes, Your Honor.
Okay, and your client doesn't have a right to choose something else. It's 169A51 subdivision 3 type of test. The peace officer who requires a test pursuant to this section, which is the implied consent section, may direct whether the test is a blood, breath, or urine. He gets to call it.
Under that statute, correct.
Under that statute. The other statute, driving while impaired, refusal to submit to chemical test, says it is a crime for any person to refuse to submit to a chemical test of the person's blood, breath, or urine under 169A51. What the Court of Appeals said is that there's a transitive verb in there, and so it is only the method of testing. It doesn't incorporate the officer's right to choose. What I want to get out of the way, if we can, before we get to your Fourth Amendment argument, is do you agree that the police officer had the right to tell your client which test she was going to take? And once he did that, then it becomes a fact question whether she passively refused to take it.
Your Honor, I think the Court of Appeals correctly interpreted 169A.20 in that it is, my client is not, under the criminal law, required to follow or is not penalized for refusal to follow the law under 169A.52. And I think that's where the officer can decide. .51, I think the Court of Appeals correctly included, does not permit the officer to decide. But I think along those lines of which statute applies, I think more importantly, Your Honor, the Court of Appeals found that under 169A.51, it's a crime to refuse to submit to testing. And clearly she did submit. It does not make it a crime to refuse to provide a sample. And I think the Court of Appeals made that distinction as well. And that, I think, is probably a more important distinction, Your Honor.
If that interpretation is correct, why isn't it a fact question about whether or not she, in fact, submitted to the test? The officer said, I want you to do a breath test, went through the implied consent advisory, gave her the right to counsel. She agreed to take a breath test, but then she didn't do it, according to the officer's testimony. And your client's testimony was, I wanted to do this other thing, and I did do this other thing. So why isn't that a fact question about whether she actually submitted to a chemical test?
No one submits in this case, Your Honor, that my client refused to submit. She said, I'll do it. She opened herself up. She was not going to interfere with a blood or urine test. She even submitted to a breath test. She provided air into the machine. So she submitted to the test. The crime here is not that she refused to submit, but she was convicted for refusing to provide not just a deficient quantity of air, but a deficient quality of air. And that's one of the problems with breath testing cases.
Of course, none of these, you didn't make any of these arguments to the district court.
I did, Your Honor.
Where?
Throughout the record, what I did is I brought a post-trial motion to ensure that on that one particular issue regarding the 3.5 minutes, that be made part of the record. But throughout the trial, I made these objections to the court, and they were all denied. In addition, Your Honor, I think that because the state did not raise this issue at the Court of Appeals, if anything, it's
sorry, the state did not raise what issue?
The issue that it's claiming now that the defense or the respondent in this case did not raise the issue about the issue to which we're speaking at the district court. In fact, the state did not make this claim at the Court of Appeals, asserting waiver. So it in itself, ironically, has waived that issue. But indeed, throughout the record, I objected on all of these grounds. So I think it's preserved.
So is it your position that we have to reach this? You heard the state's lawyer say you don't have to reach the statutory interpretation question in order to decide the due process issue. I take it your view is we do have to decide whether the criminal refusal statute incorporates the definition of refusal in 169A.51 in order to answer the due process question.
Yes, Your Honor.
Okay, then tell me how you give effect. Your position is that the definition in Section 159A.51 does not apply to the criminal refusal statute. So, right?
Well, I think, Your Honor, we're dealing with a criminal statute, obviously, so it has to be narrowly construed.
Well, it's interesting that you say that because we have case law that says the DWI statute is remedial and it has to be broadly construed in favor of the public interest.
Your Honor, and that's probably, if I could make any point here, this is the most important point I have to make. Because there's a parallel civil law, and much of our body of law under DWI law has been construed under the civil law. Under the civil law, that is remedial, and it is to be broadly construed. And so courts have been careless in using that civil law to interpret this criminal law. In any criminal law we have, this is black-letter law, it is to be narrowly construed in favor of the defendant. Conversely, if it's a civil implied consent law, where the risk is not of incarceration, but only of a loss of license and administrative penalty, then it can be broadly construed.
Let's just walk through the criminal refusal statute for a minute. Subdivision 2 specifically is what I want to walk through with you. And what I want to know is if you're right and that we don't use the definition of refuse under Section 169A.51, how do we give effect to the language in Subdivision 2 where the legislature wrote, it is a crime for any person to refuse to submit under Section 169A.51 or 169A.52. What do the references to the other statutes mean?
I agree that that's problematic. It is problematic. But if I could just say, Your Honor, I think we're focusing too narrowly on the issue here. I don't think anybody, certainly the state doesn't even contend that my client refused to submit. Now, one of the problems with the refusal law is how do you define refusal? If we're to use the jurisprudence that's been created out of the civil implied consent law, when it comes to a criminal case, we have a bevy of problems. What if a person is silent? What if, as in this case, as the state contends, there's verbal consent but lack of action? What if there's a delay? If the person's speaking with their attorney under the civil implied consent law, that officer can cut them off at a time that they deem appropriate. And if the person doesn't respond at that point, the officer deems them a refusal. If the person says they're too drunk to take the test, then they're considered to have refused. If there's a physical impossibility, unless the defendant can come forth and show it's a physical impossibility, confusion, language barrier, change of mind. In this particular case, the machine was particularly problematic. We know that Ms. Netland blew the minimum, the statutory minimum of 1.1 liters of air, because the tone was going for at least 8 seconds, maybe 9. Since in order to have the tone going or to make it audible, the person has to maintain a flow rate of 0.15 liters a second. 0.15 times 8 is well over 1.1 liters of air. But the officer did not know.
But before you start talking about substantive, I'm still trying to frame what your argument is to this court. Is your argument that to apply the civil statutory requirements for how the test is conducted and who may choose and so forth, to apply that, the civil statutes in the criminal context, is it your view that to do that would be unconstitutional because it deprives the defendant of certain due process rights?
It would, Your Honor. What it does is that
because I'm just trying to understand if you're saying don't apply it because, I mean, why shouldn't we apply the civil statutes?
Because if we were to use the civil definitions, it would create a situation of lack of mens rea. The person would be guilty under strict liability.
And I need to focus you further, which is that the only way we can do that is if we say it's unconstitutional, because I think the legislature referred us to those statutory provisions. You said, you know, it's a crime to refuse and then refer to the civil provisions. Now, either you're saying as a matter of statutory construction we aren't to go to the civil provisions, or as a matter of constitutional law we're not to go to the civil provisions.
I'm saying both, Your Honor.
And you need to lay it out for me a little more.
Okay. Well, first of all, I believe that it's unconstitutional to make someone, I'm going to start at the beginning, and I'll go through real quickly. It's unconstitutional for a state to force someone or compel them to waive their Fourth Amendment rights under penalty of incarceration. But this statute goes beyond that, Your Honor. Not only does it require them to waive their Fourth Amendment right, that they must either consent or go to jail, is what the statute says. But they must not just consent or acquiesce to a state test, but they must come forth and provide affirmative evidence. And that affirmative evidence, if reading the civil implied consent law, must be of a certain type, of a nature that the driver can't control. Not only must it be sufficient volume, which Ms. Netland met, but of a sufficient quality. For example, in a case where the person gives 4 adequate tests in the .02 agreement, the machine actually accepts these samples and looks at them and evaluates them. If they're not within .02, the person has to do it again. And if it happens again, despite their best efforts, they've met all the sufficient minimum requirements. If it's not within .02, they're deemed to have refused.
So your argument is that the state can't compel, in a criminal context, the production of inculpatory evidence.
That's exactly right.
But let's just say you're going to lose on that very broad proposition.
Okay.
What is it about this more specifically that violates due process? The Court of Appeals did not hold that. So you're asking for something that's much broader than what the Court of Appeals held.
Right. And I think the Court accepted my petition for review on that issue, so I don't want to ignore that either, Your Honor.
Give us, on this very broad principle that you can't compel the production in a criminal context, give us some authority.
Well, first of all, if I could use the converse to explain it, this is a radical law for which there is no authority to support the state's position. There have been there's a previous case at the Court of Appeals that the state relies on. But in that case, the Court of Appeals relied on South Dakota versus Neville. But in Neville, it says that the state cannot compel a test. In Schwerber, the state says, in Schwerber, the Supreme Court says that the state cannot compel a person to give a sample. The state can hold a driver down under Schreiner and take their blood, but it cannot threaten them with penalty of incarceration if they refuse to provide a sample in a breath test case. In Schwerber, the Supreme Court cautioned that the Constitution bars the use of testimony obtained when the proffered alternative was to submit to a test that was so painful, dangerous, severe, or violative that almost anybody would inevitably prefer confession.
Counsel, it sounds to me like the argument that you're making is inconsistent with the holding of this court in McDonnell. In McDonnell, we said that the criminal refusal statute, one of the drivers in McDonnell argued that the criminal refusal statute violates my privilege against self-incrimination. We squarely rejected that argument. And it sounds to me, even though in your cross petition you captioned this argument as some version of a Fourth Amendment argument, it sounds to me like what you're standing up saying today really is this is compelling a defendant to provide evidence against herself. And that sounds like a Fifth Amendment problem to me, which we squarely rejected in McDonnell. So are you asking us to overrule McDonnell?
I'm not. This court in McDonald, if you were to take that quote out of context, did say that. However, it's McDonald versus Commissioner. It's a civil implied consent case, which again is to be the law is to be liberally construed. This is, I believe, one of the first. This is a case of first impression in a criminal context, and so I don't think McDonald's applicable.
Did you argue to the district court that the criminal refusal statute violates the Fifth Amendment?
Not the Fifth Amendment, the Fourth Amendment.
Where in the district court? Where specifically in the record? Did you argue to the district court that your client's Fourth Amendment rights were violated here?
In the pretrial motions, Your Honor, at the Rasmussen before trial.
And
yes.
Wasn't the issue there whether or not the officer had probable cause to stop your client?
That was one of the issues, but not the sole issue, Your Honor. I think we need to look at State v. George, which is a case that this court had a few years ago in the Dezo and Henning, which is the plate impoundment case. First of all, with George, that's the search case of the Harley. An officer has a right to request a search. But at the same time, the defendant or the driver has a right to say no. Consent must be received, not extracted. And so that is clear black-letter law, and this law is a radical change.
I might be misunderstanding the State's argument, but as I understand it, the Court of Appeals upheld, they rejected the Fourth Amendment argument not because there was valid consent. They agreed with you on the consent issue, and the State's not pressing that issue before this Court.
Right.
Excuse me?
The State concedes it as well.
Right. So why are you arguing consent to us here? Nobody's asking for the Court of Appeals decision on that issue to be reversed.
I am. That is the defense position, and it's a substantive due process. That is argument. That is, if the State punishes a person for refusing to waive their Fourth Amendment right, that violates substantive due process. And that is the issue that I brought before the Court.
So it's not a Fourth Amendment argument. It's a substantive due process argument.
Yes, Your Honor, to be precise. So if a person refuses to consent, they're penalized. I mean, it is. Consent or go to jail. And the State argues it's proper because of the carnage on the highways. Well, the State can and should address that issue, but it must do so without doing carnage to the Constitution.
What case law do you have to support your substantive due process argument?
I think probably the best case is the Frost case, which says, if I could quote for this court, the power of the state in that respect is not unlimited. And one of the limitations is that it may not impose conditions which require the relinquishment of constitutional rights. If the state may compel the surrender of one constitutional right as a condition of its favor, here the implied consent.
What was the factual issue in Frost? What was that case about?
Frost was the case where it was excessive regulation of a railroad. The railroad had to essentially waive certain constitutional rights in order to operate. And the U.S. Supreme Court said, no, you can regulate the industry, but you cannot, and you could give the citizens and companies additional rights, but you can't give someone an additional right in exchange for relinquishing a fundamental constitutional right, because eventually you can legislate away the Constitution. And that's what was said in Frost. And I think, Justice, you wrote about that in the Colosimo case, the Frost decision in your dissent. And that's precisely what we have here. And so I could stand up here and argue about, I see my time's almost up, I can argue about this is a slippery slope that we've gone down, and if we don't do something now, that we're going to be dealing with inquisition versus an accusatorial system. I'm not arguing slippery slope. This is that time. This is that case.
Counsel, I don't believe the Supreme Court has yet decided whether it's constitutional to criminalize a refusal to give potentially inculpatory evidence. I don't think they've decided that.
No one
unless
has, right.
they've done it like in the last week or so.
Mm-hmm.
But haven't we signaled in Schreiner how we would decide that case under the Minnesota Constitution?
Well, I think it's okay under Schreiner to force a person or force a blood test because of exigency. But it's not okay to force them to consent under penalty of incarceration. Hold them down, take the blood. But if they don't voluntarily stick the needle in their own arm, don't throw them in jail. Or in a breath test case, have them, if they submit to the test, if you can't throw them in jail.
Is it akin to saying if police officers are in hot pursuit and they enter your home in hot pursuit, to separately make it a crime to have tried to stop the police? Is that what you're saying?
That's a great analogy, Your Honor. In that particular case, in hot pursuit, if the police enter the home, the name of the case from this court, excuse me, but if the person just stands there and submits to the search, that's fine. But under this law, under that analogy, the person would actually have to provide the evidence to the police. Let's say it was a drug case. To say, search my house, that's fine. But this statute would criminalize a person who does not go and show the police their stash.
Do you know if the U.S. Supreme Court has any cases pending on its docket to answer the question of whether a state can criminalize a refusal?
No. In fact, only 9 states criminalize refusal. Minnesota is by far the most severe. Actually, making it refusal is more severe than the violation of the underlying law itself. In fact, it requires in its statute that the officer read in the implied consent advisory that Minnesota makes it a crime to refuse. And so, because it's coercive...
You've reached the end of your time.
Thank you. May I wrap it up, Your Honor?
Briefly.
Because this statute coerces consent, it is a violation of due process to criminalize the refusal and throw them in jail for refusing. And it's even more of a violation to penalize someone for providing a sample but not providing a sufficient sample or of the right type or quality. Thank you.
As Ms. Lex, you have 10 minutes.
Ms. Cox, do you agree with the statement that there are only 9 states that penalize refusal and that Minnesota has probably the most broad statute as what constitutes refusal?
I'm not familiar with the refusal statutes or penalties of other states, Your Honor. I would like to address the idea that the refusal statute violates substantive due process that has come up in Mr. Ramsay's argument.
Before you begin that, could you tell me whether or not this argument with respect to substantive due process under the Fourth Amendment was made at the district court level?
I don't believe so, Your Honor. State v. Mellett, a Court of Appeals case from 2002, addressed whether the refusal statute violates substantive due process as an intrusion on an individual's privacy and decided that it does not. They balanced the compelling government interest against the intrusion by the state against the privacy interest and determined that those interests, the balancing of those interests, favored the intrusion on privacy. And that was a Court of Appeals case, so it's not binding on this court. However, the issue has already been decided against Mr. Ramsay in one court in this state. Regarding his Fourth Amendment argument, I would like to sum up my position on that briefly. The essence of the state's argument, the state concedes that consent that's been extracted rather than voluntarily given is not true consent. The state concedes that the refusal statute can't be based on the Fourth Amendment concept of consent. However, assuming that the state has some legal authority to require a blood test, the state has legal authority to criminalize refusal to cooperate with that testing procedure. I believe the court in Schreiner, this court in Schreiner recently has essentially made my argument regarding exigent circumstances supporting the implied consent law. And though Schreiner applied only to...
Counsel, here we're not talking about probable cause that the defendant committed a felony. And that was Schreiner. And there the state was found to have the right to take blood without consent. Here, we're not in the taking blood without consent, which I think everyone would agree is the most invasive method for preserving this evidence. Here, the state's only right under the civil side anyway is a breath test.
Or a blood or urine test, Your Honor.
They can't compel a blood test, though.
Correct. If the state chooses to abide by the implied consent law, they can't compel the test. But they would have a right to demand it under the reasoning in Schreiner.
But not under the facts of this case.
I don't see why, Your Honor.
Well, you can hold someone down and take their blood if you have probable cause to believe that there's been a felony committed.
Your Honor,
death or serious bodily injury.
Mr. Ramsay's argument was that the state should be required to get a warrant before taking blood. I believe that Schreiner shows that no warrant is required to demand a breath test under the implied consent law.
No, his argument is that it's unconstitutional for the state to criminalize a refusal to cooperate in producing the evidence. That's the issue that we accepted cross-review on.
Well, I think that I would agree with Your Honor's assessment that that's a Fifth Amendment issue, compelled self-incrimination, and I would disagree with that assessment because the defendant is not being compelled to do anything. I mean, the
defendant's being compelled to submit to a test, and the argument is that you can't criminalize.
Correct, Your Honor, but if the test is legally authorized, I don't see why you couldn't compel somebody to submit to it and criminalize the refusal to do so.
Well, you couldn't compel it if it's in violation of the Constitution, could you?
No, Your Honor, but I don't believe it is in violation of the Constitution here.
I guess what we're trying to get at is explain to us why not.
why the implied consent law is not in violation of the Constitution, or why it's not in violation of the Constitution to compel a person to provide a sample.
Why the criminal test refusal statute?
The criminal test refusal statute?
Not violative of the Constitution.
Because the implied consent law, which authorizes blood, breath, or urine tests to be taken from people who are suspected of DWI, is not unconstitutional. And it's within the legislature's judgment that rather than forcing through physical confrontation people to provide samples, they can give people the choice and
we've said it's proper to punish is maybe not the right word, but to sanction an individual for refusing to comply with the complied consent law. But now we're talking about criminal test refusal. We're not talking about the implied.
I'm not sure what you're getting at, Your Honor. Why it would be unconstitutional? Why it would be? Are you implying that it would be unconstitutional to criminalize refusal, even though we could revoke a driver's license for refusal?
I guess that's the implied consent is civil.
Correct, Your Honor.
The 169.20 is criminal.
Correct, Your Honor.
It seems to me that what may be constitutional in the civil setting may not be constitutional. And I don't know the answer to that, but it may not be constitutional in the criminal setting. I want you to explain to us why it is also constitutional in the criminal setting.
Your Honor, it may be true that there are things that are permissible, constitutionally permissible in the civil setting that are not constitutionally permissible in the criminal setting, but I guess I'm not sure what that argument is based on in the context of test refusal. It seems to me that if the legislature, or if the test refusal statute is constitutional, if the state can constitutionally require a blood, breath, or urine test, that there's no constitutional barrier to the legislature making the refusal to cooperate with that process criminal as well.
The sanction is dramatically different. One is loss of license, the other is potential incarceration, loss of liberty.
That's correct, Your Honor. I guess I'm not sure how that would make a difference other than the burden of proof, and it was proved beyond a reasonable doubt that Ms. Netland violated the refusal statute. Your Honors, I guess I would close at this point and respectfully urge the Court to reverse the Court of Appeals decision regarding due process and affirm the Court of Appeals decision regarding the constitutionality of the refusal statute under the Fourth Amendment. Thank you.
Thank you very much. Thank you, counsel. The matter is submitted. We'll issue an opinion in due course.